Judge Craig DeThomasis, Judge Grudge, he just did something that the entire planet never saw coming. Our final hearing scheduled for March 1st, 2024. Today is February 28th, 2024. Judge Craig DeThomasis sets a hearing to go over motions he's been ignoring for weeks, almost a month. Motions such as a motion to dismiss this fraudulent. Yeah, that's one of LIEnette's debunking words, saying that we fraudulently got civil protection orders against her in Ohio. Except that judge isn't fraudulent, the court isn't fraudulent, and yet they determined she was and granted civil protection orders. So number one, motion to dismiss. Number two, motions for sanctions based on all of this fraudulent filing. Motions to compel depositions. In other words, due process, discovery of evidence, which has been shut down completely. And now insufficient responses to requests for production of evidence. Yeah, we're even trying to get evidence from LIEnette and Joshua Silverman, and they're not producing it. They're literally saying, well, it's Jeremy's videos. He has them already. I have over 2,000 videos, as if we're gonna take the man hours, thousands of hours to search for them. It is their responsibility to provide it. But now this judge has gone and done something out of this planet. Filed the first motion to disqualify him based on bias. Second motion to disqualify him based on bias. Third motion to disqualify him based on bias and a fear that I will not receive a fair trial. And what does he do right before the motions hearing this morning? He has to make an order based on the motion to disqualify him before he can do anything else. But as you've seen, I believe it was hearing number 2 or 3. Who even knows at this point? Today is scheduled 5. He waited to actually rule on the second motion to disqualify him as he went through all the other motions. This time, my legal team has kept them to the law, saying, you must rule on this disqualification order before anything else happens. So first thing this morning, he rules on it. And what do you think he does? He disqualifies the aspect of disqualifying himself. He said no again. Okay, now understand that the judge just has to say no. But instead of a 5, 6, 7, 8 page this time, we only got 2 pages. And he goes on as if he is a lawyer arguing his merits of why I have no fear of a fair trial. So he goes on to say this: order on the respondent's third sworn motion to disqualify. This cause having come before the court upon the respondent's third motion to disqualify, and he goes on to the case number and all that. I'm not going to get in all the case number and all the case law, although he does state it in here, which obviously our motions have stated all case law as well. Filed on February 21st, 2024, and this court having limited its review to the legal sufficiency of said motion without passing judgment on the truth of the facts alleged. The truth is, I fear that I'm not getting a, you know what? This is my lawyer right now with an update. We'll get right back to that. More mind-blowing stuff in this case that I can't share with you yet, but I will. I promise we will get to that point on WTH News, where we debunk all the LIEnettes and crooks of the world. Okay, Judge DeThomasis, he says, this cause having come before the court, which was filed, limited review, legal sufficiency, a motion without passing judgment on the truth of the facts alleged, and in consideration of said motion and applicable law, finds as follows. Florida Rules of General Practice sets forth the requirement of reviewing a motion to disqualify. Any motion is legally insufficient. So basically what he's saying is my motion is legally insufficient of me being fearful of getting a fair trial. In order to deny the motion shall immediately be entered, sets forth the requirement of proper motion. The motion under review is legally insufficient as filed. He says, while the facts alleged, the facts are, I am in fear of receiving a fair trial by this man. And he says, while the facts alleged in disqualification motion must be accepted as true, and the legal sufficiency of said motion is a question of law, legal sufficiency involves more than averment. Honestly, I don't know what that word is. Averment. And I didn't look it up and I didn't Google it. And I don't have Alexa to ask what it means right now. But you know what? That's okay, because Craig DeThomasis, he acts as God, so he can create words and use words I don't understand. That's all right. I use YouTube, and he doesn't understand it. He's proved it while trying to be elected and failing as a judge, okay? All right, the motion must state a factual foundation for the party's fear of prejudice. The motion was 61 pages stating the facts. All right, and he goes on to say, adverse legal rulings are not legal sufficient grounds for disqualification. Basically what he's saying, all of your motions mean absolutely nothing. And I hope you understand the fact that he just didn't say no, and he wrote yet again 2 pages is another reason legally for disqualification. All right, so number 3 says, in ruling on a legal sufficiency of a motion to disqualify, a judge must explain the status of the record. So now he's saying what I just told you, which we already used case law and told him, hey, you cannot converse any more than just yes or no. And now he's saying, well, on a ruling of a legal sufficiency of a motion to disqualify, judge must explain for the record. Further, a judge may comment factual on what transpired during irrelevant proceedings when rulings on the motion to disqualify. In other words, he's saying, you're wrong and I'm right. I'm the judge. You're not. And Jeremy, I'm coming after you. Number 4, in the court's prior order issued on February 14th, 2024 under subsection 7A through explained that the relevance and the material status of the record not by taking issue with the averments contained within the motion under review, but rather by identifying that it was true that there were several transgressions from applicable law and procedure engaging by counsel throughout the proceeding, which were then addressed by the court as they arose. In other words, he's arguing that when he is attacking my legal team, he has every legal right to attack my legal team as he acts as their judge as well.
So what I'm hearing is, it's my courtroom and I rogue if I want to, rogue if I want to, rogue if I want to. It's my courtroom and I rogue if I want to, rogue if I want to.
It's just, it's insanity. It is insanity. He should have recused himself. He should have stepped away from this. He's creating the most toxic
He's being really
environment
defensive
with another toxic person, LIEnette. As stated in subsection 8, the previous order, adverse rulings, he just keeps going on. It's insufficient grounds for disqualification. Further, it's the court's responsibility to assure that the orderly administration, here's the best part, this just blows my mind. It's the court's responsibility to assure the orderly administration of justice. Well, that's exactly what we're saying. There is no order in the court. There is no justice in his court. The fair application of law. We're literally saying you're being unfair in the application of law. He treats LIEnette one way, me another way. LIEnette's counsel one way, my counsel another way. There is no fairness, none whatsoever. And to assure counsel's adherence to the regulations of the bar as well as code of professional conduct, it's necessary by obligation of court to place on the record to allow responsive counsel, if any, in all transgressions and violations of the law and the standard, In other words, I'm right, you're wrong, and I will not disqualify myself. All right, per the Florida Supreme Court, then he goes on, even if the reporting of perceived unprofessionalism to the Florida bar and of itself is legally insufficient to support. Oh my goodness, my lawyer is calling again with another update. This is mind-blowing. I just can't believe it. Plot twist after plot twist after plot twist. And so much I can't share yet, but I promise you the phone is going to ring again, okay? And it will be my lawyer. There is so much going on. All right, so Craig DeThomasis, Judge Grudge, he says, as the Florida Supreme Court held in 5H Corporation versus Padavado, or however you say the name, all right. Even the reporting of the perceived unprofessionalism to the Florida bar in and of itself is legally insufficient to support judicial there's so many words, disqualification. The opinion further describes and affirms the mandate that the judges should participate in establishing, maintaining, and enforcing high standards of conduct. And yet he's the one that has no control of his courtroom. He's the one that shows bias constantly. He's the one that's evoked fear in me of an unfair trial from day one. All right. And shall require order and decorum in proceedings before the judge. The conduct of counsel necessitates such court intervention. And he says, and therefore it is ordered and adjudged that the respondent's third sworn motion to disqualify is denied. 9 a.m.-ish, he denies the motion to disqualify, which immediately my legal team already had another motion prepped if he did this, a motion to stay the trial. In other words, what stay the trial means for those that aren't in the legal system, it means everything's on hold. He has no jurisdiction over it anymore. It goes to a higher court to determine whether Judge DeThomasis is, whether we're going to be able to debunk all of his disqualification denials, and really prove that he is biased. So it says, motion to stay trial for proceedings pending a petition for writ of prohibition. All right. And just so you can see, it's already been filed. It's in his hands. And in literally 2 hours, we're supposed to be in his courtroom. And what we're saying is, no, this isn't happening. You are out of control. You're trying to play God. And there must be some higher authority that has to take over. And there is in the appellate courts. So he's saying, respondent Jeremy Hales, and through his counsel, moves to stay the proceedings pending a petition for writ of prohibition, and states notice of intention to file petition of writ of prohibition. 1, and it gives the authority under the law. Number 2, inasmuch as there has been a ruling denying and again creating further grounds for disqualification by arguing. Every time he argues the denial, that's a qualification for disqualification. So once again, disqualification by arguing, once again with the merits of the third motion. Respondent's third motion to disqualify Judge Craig DeThomasis and continuing in this matter, and 2 hearings on matters which have been pending for more than 2 to 3 weeks at a minimum have now been set for today, 2 days before the final hearing. Respondent is in the process of filing a petition for writ of prohibition with the First District Court of Appeals. Number 3, grounds for the petition of writ of prohibition are contained in the first 3 motions. In other words, we're going to the higher court because of the first 3 motions already that he's denied. And we're saying that is the grounds to go to the higher court and appeal. And number 4, one of my attorneys expects to be finished with the petition for writ of prohibition within the next 7 days. Could be sooner, except she has to travel out of the jurisdiction for evidentiary hearing and has a medical appointment in the interim. So in other words, scheduling could be a little bit of a process here, but we're moving forward. Therefore, the respondent moves for a stay. I'm the respondent. Moves for a stay of the proceedings during this pendency of petition of writ of prohibition for the First District Court of Appeals. And number 6, should the stay be granted, all the rulings on the pending motions would become subject to reconsideration should the First District issue a writ of prohibition. In other words, everything gets reheard by an unbiased judge, right? The court retains jurisdiction during the pendency of the writ, and review of the order entering denying this motion is separate motion for the reviewing of the court. Number 7, pending matters including a motion to dismiss, motion for sanctions, motions to compel for depositions, and now insufficient responses for request of production. Number 8, all in this case where petitioner evoked her Fifth Amendment privilege against self-incrimination in order to avoid answering questions about this case in her deposition, which the court declined to address in the last hearing, January 23rd, 2024. You have to understand, you don't get your cake and eat it too. LIEnette can't say, I want an injunction against Jeremy, then be deposed, and then say, oh, I plead the Fifth. That is in a civil courtroom. And I know there's plenty of individuals that keep trying to tell us, you're wrong, you're wrong. They're not lawyers, okay? In a civil courtroom, this isn't a criminal case, this is a civil case, there is an inference of guilt. If you plead the Fifth, the judge can infer, well, you're guilty then. And this is exactly what's happening. Therefore, he must dismiss the case, and he hasn't. She doesn't get to file for an injunction and take the Fifth at the same time. It's one or the other. She pled the Fifth. The injunction should be dismissed immediately, which he has refused to do. Court order depositions have still not been completed due to the manipulations of the petitioner, LIEnette, and her counsel, Joshua. And the Hobson choice for the respondent is to agree to continue to have the temporary injunction extended against him or to proceed to a final hearing without adequate discovery, and all before a judge that he reasonably fears cannot be impartial. What I'm saying is, I want this to go to the appeals. I will keep the temporary injunction on me for them to address whether this has been right or not. Now, keep in mind, the injunction does very little on my daily life except living my life, freedom of speech, right to bear arms, access to my property, access to the road. You know what? It alters my entire life in a negative way, holding me responsible for the lies of a pathological, stalking, horrific, horrible neighbor. I hope you grasp that. But I'm headed back to Ohio anyway, and I will be back for every single meeting, and George will be back for every single town hall meeting. So the reality is, if she shows up, she's going to be arrested. Maybe. Levy County Sheriff aren't doing too much, but Ohio's all over it. Respondent requests a ruling as soon as possible. The respondent, being me, requests that this court order that these proceedings be stayed or everything put on pause, is what that means, until the higher court can review what Judge DeThomasis has done in here. Until the First District Court of Appeals rules on the petition for writ of prohibition and any other relief that this court feels is just and proper. So, what does that mean? It means everything right now, as we are 2 hours away from going and hearing him on motions, and then 2 days later, the final hearing, he has to rule on this. Now, what's happened thus far is Joshua Silverman, counsel for LIEnette, somebody so foolishly, she gave LIEnette $7,000 that she'll never see back again. It's gone. She might as well just thrown it in the fire, because all this has done is further incriminate LIEnette. And those cases are coming too in the courts. So what does this mean? Well, Silverman has already said he's going to tell LIEnette, you need to agree to this. And so right now you've got me saying this needs to be stayed and it needs to be reviewed by the appellate courts. And Silverman saying, Joshua saying, yeah, we agree. And so what's Judge DeThomasis going to do? He should just say yes. Now, will he?
He's going to pull a Don the Con and go, no.
No. We are at the courthouse. As a matter of fact, Amanda Martin might be right there. I think I see her. They're all going out on break. That could be Amanda Martin over there. I tried to park in the most convenient area to protect myself, because who knows what she has planned this time. And we have not seen Crook or LIEnette yet, although we're pretty confident they're still going to break the civil protection order. But we are 40 minutes early. So the judge, Craig DeThomasis, Judge Grudge, has not said anything about the stay motion yet, which means we are still on schedule, on the docket for court, where anything literally can happen. LIEnette's changing it up. She just walked past us. She's right there. We don't know where Crook is yet. She's in flip-flops for court.
She's wearing that headband.
And dyed her hair just to look like George. So somewhere down here.
Well, they're not parking in their usual spot, which is good. They know
that's
not
good.
To be within 500
maybe
feet
they actually are getting the point that they're going to jail if they keep doing this.
And that they're not above the law. There she goes, walking right in. Where's her parachute bag with all her fraudulent evidence?
The world may never know. Court's officially over, and this time we were only in there an hour. Hey, we only had to hear him talk about Mark Feathers 2 times? Co-counsel? 15 minutes? I can't believe this man. And then he goes on a verbal attack of me, which is pretty interesting considering I'm the one that got attacked by his court's victims advocate's son. And when my lawyer brings that up, he's like, you expect me to know about this? You think I know about any of this? It's interesting because in the actual court hearing, at some point, my lawyer, Randy, says, can I please speak without being interrupted? And he goes, I know you think I'm interrupting you, which proves again, He's watching the videos because we show interruption after interruption after interruption. Guess how many times he actually interrupted Joshua? 0. None. He actually made some snide comments to me as well, because he says, and now the respondent, he's laughing. I wasn't laughing. I was beyond mad because this man keeps trying to say that I did something. I've done nothing to this woman. I've shared truth about this woman. And this woman should have never done what she's done. A court's already found her guilty. So here's something you want to keep in mind. Since we've called LIEnette on 4 hearings so far, wearing no mask, hearing number 5, guess what? She wears a mask. You're going to get to see this hearing because we're going to go ahead and we're going to get it. Oh, wait, will it be redacted or unredacted? It doesn't matter. They're both the same, right? All right. So basically, in a nutshell, there were a number of different motions, 7, 8, maybe even more motions that this judge has been intentionally ignoring. All right. And so 2 days before the final hearing, he actually, here we go. I'm getting, oh man, this is my forensic handwriting expert right now. I can't take it. She's going to have to work with my actual lawyer. So all in all, there were 8 to maybe more motions that he had to actually rule on, except, keep in mind, he denied the 3rd disqualification motion. And then we filed this morning to actually have the higher courts review all of this, particularly to review him for all this bias. So he comes into it already upset. And so he does appropriately say, well, maybe it'd be more efficient to actually just look at this versus all the other motions first, which it would be, right? To stay the case. Or in other words, to put it on pause, have the higher courts look at it, see if there is bias. Listen, there's nobody who is going to watch the videos of these trials or read these transcripts of his who is going to say, oh, no, he's not biased. There's no way in hells anyone will find him impartial. It's beyond evident. It is beyond obvious to anybody who's seen it. So he literally starts arguing about staying this thing again or putting it on pause so the higher courts can actually rule. He's arguing again as if he's a lawyer. He's not a lawyer. Now, he spent many, many, many years as a criminal defense attorney, and he still apparently thinks he is one.
He can't take that hat off in his courtroom.
The teaching, he was an adjunct professor. I'm an adjunct professor, or was. I'm no longer certified in regards to that. But I get it. I mean, he wants to teach everybody everything. That's not his job. His job is to listen as a judge and find facts that adhere or don't adhere to the law and make orders based on it. That's it. The man cannot keep his mouth shut. And he wants to run his mouth over and over and over about me. Funny part is, at one point, Silverman, Joshua, even says, well, Jeremy's not too concerned about the injunction. He's all over YouTube saying that he doesn't even care about the injunction. It doesn't affect him. No, let's clarify. I've been very, very clear that this injunction does nothing in the aspect of communication. I don't want communication with her. I don't want her anywhere around me. That means nothing to me. But this thing also has taken away my First Amendment right, which means everything to me. This also has taken away my Second Amendment right, which means everything to me. Because she's the type of person I have to protect myself from. He's the type of person I have to protect myself from. All my access to my land has been taken from me illegally. Access driving on the public road has been taken from me illegally. Contact with the injunction, communication with the injunction, being near her with the injunction means nothing to me. I don't want her near me. I don't want her talking to me. That's what means nothing. Everything else has infringed upon my rights as a U.S. citizen. These are civil rights that are being attacked. So, other things that went on in the actual hearing. Believe it or not, Joshua actually agreed. Yeah, let's stay this thing. Except he used a different word. He said, well, let's just use the continuance. We'll just put it on a continuance, an indefinite continuance on the calendar until the higher courts actually decide what they're going to do. So, Joshua, you obviously are watching. You've proven that you're watching. Thank you. I think that was kind of you. And I think that was respectful of you. And I think that that was the right thing to do. And I also, and this is just my opinion, think that Joshua has found out how wrong he was to take this individual, LIEnette, on as a client. And now he's seen how deep this hole goes. And I wouldn't doubt he wants out. Who wouldn't want out representing her, right? And so there was agreement on both sides. Petitioner, LIEnette, or through her counsel, Silverman, Joshua, and then the respondent, myself, or through my lawyer, Randy Shockett. And there was agreement, hey, let's let the higher courts look at this. Let's let them make a decision. But Joshua was very clear, and he stated, I want to make it very clear that just because we're agreeing to this doesn't mean that we agree to their motions to disqualify. Now, I get he says that on record. I also think he's a better man than that. And I've said this before. Outside of this circumstance or situation, listen, I have lots of people that I call acquaintances and even more friends. And I get along with just about everybody until you try and steal from me, take from me, lie from me. I got some pretty major issues there. I get along with almost everybody, and I have no doubt I would get along with Joshua without any problem outside this circumstance. And so he wanted that to be as a continuance, which then Judge DeThomasis is attacking my side for so many continuances. Well, keep in mind, I've only ever asked for one continuance. Every other continuance was based on her side. I've asked for a continuance once, which was based on her as well. She literally is trying to incriminate my lawyer, stating that he tried to bribe her and pay her off. Therefore, he is now a witness. He's no longer my counsel. And so I have to find counsel within 24 hours. I hire Randy. So, whose fault is it that I needed a continuance to have proper representation? LIEnette is the one that lied about my first lawyer, Mark Feather. Everything's been continued based on him, and I mean Judge DeThomasis, talking over and over again about the same stupid stuff. He's like a scorned woman, 30 years later, bringing something up. It's out of this world what he continues to do. Based on a bomb threat, which, again, it's all based on LIEnette. It's all based on LIEnette. Dodging depositions, Crook dodging depositions, dodging discovery, not providing discovery. Now she gets a gift of $7,000. By the way, the $7,000.
Don't forget the dying mother.
My mother's not dying.
My mother's not dead.
So,
or her pretending that she didn't know she had to have a deposition.
Oh, by the way, that was brought up as well. The unfairness, and I have to comply with the court, but he has not made her comply with the court about her dying mother. The judge still is neglecting that, doing nothing with it. You want to talk about bias? Jeremy shows you the airplane tickets. Jeremy gives you copies of the notarized court documents, and that court hearing happened. And he tells her, hey, don't worry, just a gas receipt. And he still hasn't forced her to provide anything as proof why she dodged the depositions. It's insanity. It's insanity. And then he goes, well, if we stay or we continue this, the respondent, Mr. Hales, is still going to have an injunction on him. No kidding. We now have, is this the fourth extension of a temporary injunction? So I still have a temporary injunction on me while we wait for the higher up court to actually look at this and see if DeThomasis is being biased or not, which we all know he's beyond biased. This is beyond bias. And at one point, my lawyer, Randy, very rightfully so, as DeThomasis is saying, well, if we stay this or if we continue this, then there's still the threat there's still a threat for the petitioner. And Randy is going, the only one that's been attacked is the respondent by your court's victim's advocate's son. And then I'm like,
And he's going, and now the respondent's laughing. Laughing? Do you have any idea how upset I am? My legal rights have been taken away from me. I'm being assaulted by individuals that are connected with DeThomasis. He's taking her lies as truth. There's been not a single aspect of fact shown yet that there's any evidence that I've made anybody ever contact her. Do you understand? YouTube isn't a person. I'm a person. YouTube isn't. YouTube, if you want to watch something or see something, you have to log in and look at it, just like you are right now. Nobody forces you. Nobody makes you. Anybody who watches anything I put out, you choose to. Other than that, it's just a diary of my life. It is a video diary of my life. And now she's trying to say, but she's, oh no, so bad. Stay out of my life. If you stay out of my life, then guess what? You're not in the diary of my life. But here we are, months and months and months later. And this could be in the higher courts for 6 months, 9 months, maybe even a year before anything else is resolved.